Kevin Thompson's.
Yeah, I remember that.
They played football together, Your Honor. He's a big guy.
I remember.
Yep. Congenial.
Yes.
We've worked well without this, but we've got one issue that we just haven't been able to agree on.
Well, let me see if he's here. And he is. Bring him in. Good morning, Mr. Jennison. Shannon, put us on the record, please.
Excuse me?
Okay, this is the matter of Hill versus Hill. Mr. Berkemeyer is present in person, but unfortunately my Polycom is not working today, so you won't be able to see him. I've asked him to approach the bench so you can at least hear him.
Okay.
Shannon, Mr. Berkemeyer represents the plaintiff. Mr. Craig Jennison, you need a spelling, represents the defendant. And I understand that you folks are very, very close to resolution, but there is an issue. You want to enlighten me as to what that issue is?
Your Honor, my understanding is that the only issue that we're have left is whether or not the income tax exemption should be alternated between the parties. We would ask that the court order that it would be. It's my understanding in dealing with all the courts up here that that's a standard practice, is that the income tax exemption with the condition that the person who is paying child support has to be current in this child support obligation in order to receive that income tax exemption for that year. So I believe that's the only issue, is we're asking that they alternate the income tax exemption for the minor child.
And there's just one child?
Yeah.
Just one child.
Okay, and Mr. Berkemeyer?
Your Honor, this is a case where my client believes she had reached a full agreement with her husband, and I was putting it on paper and in contacting Attorney Jennison about it. It was the first time that the tax exemption was brought up, and he says his client would like that. So I addressed it with my client. She says it's nothing they ever discussed, and she asked me about it, and I says, well, according to the IRS code, you're entitled to it if you have the majority of the overnights. And she has almost all the overnights. He's just started one overnights a week, and he's going to 2 overnights starting in March, Your Honor. But she is certainly entitled to it under the Internal Revenue Code, and I believe that that's what she wants. And so that's the only issue we haven't been able to agree on. And I believe that she believes that they work together in reaching a resolution of all the other issues. This was not something that was ever discussed between them until it was brought up by her attorney. And it's not something that she should have to concede to.
So, Mr. Jennison, there might be some standard practice where you normally practice. I've not observed that in this county there is a standard practice, except when the parties share custody equally, and there it very often is an alternating thing. My default, if this were to come to trial, and it may, if you guys can't agree on this provision, I'm likely to award that exemption to the person that has primary custody.
Okay.
So you can explain that to your client and then ultimately decide whether or not you're going to have a consent judgment or not. I realize if you haven't agreed on it, I can't force the issue today.
I think we were of the agreement, Your Honor, that we would resolve it with your weighing in on how this would, you most likely wouldn't rule on it.
Right, but I understand that still this is subject to Mr. Jennison's client's acceptance. He could decide to say, well, if we don't have an agreement on that, then I'm going to go back and fight with everything else. So ultimately, what's your pleasure this morning, Mr. Jennison? Do you need to speak with your client?
Yeah, I would like to speak with my client, Your Honor. I believe that you know, in discussing it with him prior to this time, that I'll discuss it with him further, and I believe that maybe I can give Mr. Brinkmeyer a call and maybe get this thing resolved without that trial.
So I noticed that both your clients are in the waiting room. I did not bring them in. Pardon me for that. I was assuming that it was just going to be attorneys this morning. I do have the ability to put you and your client into a breakout room if you'd like to get this resolved yet this morning.
If you can, yes, Your Honor, I might be able, can I talk to him right now?
Absolutely. Let me bring them both in. I have to do that, I think, before I put them in the breakout room and tell them what's going on. So Shannon, both of the parties are now joining us. So Mr. and Mrs. Hill, my apologies. I've been on the record with your attorneys, and I didn't realize that you both were in the waiting room. We had a conversation on the record regarding the issue over the tax exemption. I expressed to the attorneys how I would typically rule in such an arrangement. Mr. Hill, Mr. Jennison has requested that I put you in a breakout room so that the two of you can discuss the issue and figure out whether or not we're actually able to enter a consent judgment this morning. So I'm going to create a breakout room.
Okay.
And I'm going to put you both into it. And Mr. Jennison, when I see you come back, I'll probably be on another case, but when I see you come back, I'll move quickly back to your case.
Okay, thank you, Your Honor.
Thank you, Your Honor. Thank you, Craig.
Thank you.
Okay, there we go. You'll need to hit a command on your screen to put you in there. So Ms. Hill, I'm going to put you back in the waiting room until they come back.
Okay. Thank you.
You're welcome.
Are they going to get a new line for you before you retire, Your Honor?
I sure hope so. We keep inching closer, don't we? Okay, Mayaki versus Mayaki. Let me see if your clients are in the waiting room.
My client is in my office, Your Honor.
Oh, okay. I don't, let me just check. Sometimes people's, oh, here we go. Yes, Mr. Hotchkiss, your client is. So let me bring her in. Okay, Mayaki versus Mayaki, Mr. Rapley for the plaintiff, Mr. Hotchkiss for the defendant, and both parties are also present. Shannon? So I have a judgment of divorce in the file. Are we resolved? Are we able to take proofs today and enter a judgment?
We are, Your Honor. This case was arbitrated by Mr. Fabian. He issued an opinion. I believe that the judgment is consistent with that opinion and asking that you sign the judgment.
All right, I got to make sure which one because I got three in front of me.
It'd be the
How
warm
will I know
one.
which one? The warm one?
Yeah,
All right, Dawn just handed me one.
that's the last version. Mr. Hotchkiss requested some changes.
Yeah, take these so I don't get confused. Okay, so I still need to take proofs though. So Mr. Mayaki, would you raise your right hand, please? You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Put your hand down, state your full name for the record.
Brian Mayaki.
Go ahead, Mr. Rapley.
Thank you. Mr. Mayaki, you signed a complaint for divorce some time ago. Do you remember that document?
Yes.
Were all the allegations and the information contained in that document true at the time you signed it?
Yes.
Do they remain true today?
Yes.
Were all the children that were born or adopted listed in that document?
Yes.
You alleged that there had been a breakdown in the marriage relationship to the extent that the objects of matrimony had been destroyed and there remained no reasonable likelihood the marriage could be preserved. Is that a true statement today?
Yes.
You and your wife participated in an arbitration hearing with Mr. Fabian. Do you remember that process?
Yes.
And he authored a decision and you've had an opportunity to review that.
Yes.
And you've reviewed the proposed judgment as well. Is that correct?
Yes.
In your opinion, is the judgment consistent with the information that Mr. Fabian laid out in his opinion?
Yes.
To the best of your knowledge and information, is your wife currently pregnant?
No.
And you're asking the court to sign that judgment and grant you a divorce?
Yes.
Thank you. Nothing further, Your Honor.
Ms. Mayaki, can you confirm to me today that you are not pregnant?
I am not correct.
Thank you. Mr. Hotchkiss, do you believe the proposed judgment comports with the arbitrator's ruling?
Yes, Your Honor. For the record, I have discussed the proposed judgment with my client. We have made some changes as recently as maybe a half hour ago. I do believe that it comports with Mr. Fabian's decision in this matter, even though my client is not satisfied or happy with the result. We both believe that it does comport with the decision, and I don't see any legal reason why the court should not sign the judgment. Thank you.
All right, I am satisfied based on the proofs. There's been a breakdown in the marriage to the extent the objects of matrimony have been destroyed. There remains no reasonable likelihood that the marriage can be preserved. Since the matter was submitted voluntarily to arbitration, the parties agree that the proposed judgment of divorce comports with the arbitrator's decision. I'm going to grant it today. All right, we'll see that Dawn gets a copy back to both of you. Thank you.
Thank you.
Thank you.
Okay, let's go back on the Hill matter. Mr. Jennison, you've had a chance to speak to Mr. Hill. What is your pleasure regarding the proposed judgment of divorce?
Yeah, I talked to my client. He is now would be in agreement with the judgment of divorce that was sent to my office, and he will sign that judgment of divorce.
Your Honor,
Just a second. I'm sorry. I forgot to bring Ms. Hill back in. Ms. Hill, can you hear me?
Yes.
My apologies. I should have brought you back in immediately. I've just been informed that Mr. Hill is willing to sign the proposed judgment of divorce as submitted.
Your Honor, there is one additional matter from the proposed judgment that I sent to Mr. Jennison that was subsequently discussed between the parties and between myself and Mr. Jennison, which I believe we're in agreement on. It appears at the bottom of page 3 is the last paragraph. I added, Mr. Jennison, it is further ordered in a judge that in the course of their parenting time, each party shall inform the other party whenever they intend to travel to another state to include dates of departure and return, destination, and emergency contact information. That was, I copied it verbatim from what I discussed with you on the phone.
That's correct, Your Honor.
Okay, well, we need to take some proofs in support of this judgment.
I think we previously took proofs.
Oh, I didn't have it noted in the file. When did I do that?
I'm not, maybe we did not do that.
We did, but we did it on December 10th. We need to renew those proofs.
Okay.
So Ms. Hill, would you please raise your right hand? You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You can put your hand down now. Please state your full name.
Caitlin Martha Hill.
Your attorney has some questions for you now.
Ms. Hill, you caused there to be a complaint in this matter filed for divorce. Is that correct?
That's correct.
Were all the allegations true when you made your complaint?
Yes.
Are they still true today?
Yes.
And you allege in your complaint that during the course of your marriage, there was a child born, and that's Poppy A. Hill, and she was born on May 10th of 2019. Is that correct?
That's correct.
And there's, you're not expecting any other children at this time. Is that correct?
That's correct.
You're not pregnant.
No.
And Ms. Hill, you've alleged in your complaint that there's been a breakdown in the marriage relationship to the extent that the objects of matrimony have been destroyed and there's no reasonable likelihood that the marriage can be preserved. Was that a true statement when you made it?
Yes,
Is that still a true statement today?
it is.
And you and your husband, as I understand it, have totally separate lives at this time. You've moved on. Is that correct?
I have, yes.
And we've reached a resolution of all the issues in this case, and it's been presented to the court in a proposed judgment, and that's something that you have agreed to, all those terms and provisions. Is that correct?
That's correct.
You believe them to be fair and appropriate under the circumstances. Is that correct?
That's correct.
I'm satisfied.
Mr. Jennison, did you have any questions for your client?
No, Your Honor.
All right, I am satisfied based upon the proofs there's been a breakdown in this marriage to the extent that the objects of matrimony have been destroyed. There remains no reasonable likelihood that the marriage can be preserved. I am signing the proposed judgment of divorce. I'm going to give that to Mr. Berkemeyer and charge him with the responsibility of getting you a true copy.
Thank you, Your Honor.
Thank you, Your Honor. Thank you very much,
thank you.
Mr. Jennison. I'll be sending
Thank
you the
you.
true copy.
Okay, thank
Have a
you.
good day, everyone.
Thank you.
Thank you.
Yeah, that I was too. That was definitely a, sure don't think anything like that's gonna happen to someone that. I mean, last I heard she was doing okay, but it's been a week, I would say, since I've heard anything. I, for real. Yeah, you too, though.
Be safe.
It looks like it's gonna be fairly nice out.
This was my very last divorce case. I still have a couple with little issues week after judgment, but I'm glad to have no further divorce cases.
Are you retiring or just not taking any more divorces?
I'm mostly retired, Your Honor. Most of the cases I have to wind up now are probate matters. I'd always hoped, I shared space with Dennis Cohen since 1989. I always hoped that we would find some young guy to come in, kind of ease the transition to retirement. But that never happened. So then I always felt comfortable. Well, Dennis isn't ready to retire. I'll be able to have him help me finish things up. But Dennis and COVID, his wife has some very difficult health issues, and they've been just like paranoid with COVID. And so he wasn't around the office at all. And, so that didn't work out either. So now I still got things I'm trying to finish up. This was one of them. So
Well, don't be a stranger.
Yeah, well, good to see you.
Likewise.
I hope they get a new live one.
Yeah, I'm looking forward to getting back at it. Okay, this is McConnell versus McConnell. Shalini Nangia, representing the plaintiff. Do you need a spelling? Okay, and let me see if Mr. McConnell was here the last time.
He should be in your waiting room, Your Honor.
Is he Roberto?
Yeah.
Okay. I just clicked on him and he'll be hopefully connecting shortly.
Are you doing in-person hearings, Your Honor, or just virtual?
Mostly virtual. The gentleman that was just here is a local attorney, and occasionally they request to be here in person. I've tried to be accommodating of that. We are relaxing a little bit starting next week. We're moving on to phase 3. I'm still strongly encouraging people to continue participating by Zoom. I think for people particularly who are from out of town, it's probably a lot more cost effective. The
That's
other
for sure.
advantage, the other advantage too, is that when I have attorneys in person but parties by Zoom, it's challenging. And it's better if we do it all by Zoom or all in person, because invariably there's an opportunity for a consultation and perhaps resolution of some issue if you can speak privately with your client, which works great on Zoom. I just put you in a breakout room.
Yeah.
Sorry, I just reminded me to close the breakout room. When the attorney's here in person, but the client's on Zoom, it's just about impossible. I have to send the attorney out into the hallway to find a place where they can have a private telephone conversation. So
right.
Anyway, so we are here on the matter of McConnell versus McConnell. I know you were here previously seeking release of a judgment lien. I had concerns about the acknowledgement that we don't know where Ms. McConnell is, and it's virtually impossible to give her actual notice. I think I directed you to publish. Were you able to do that?
Well, actually, what we discussed last time was you were going to talk to your staff and have them call the friend of the court, because we talked about, Ms. McConnell's duty to update her address with the court. Okay. And it was determined that the court did in fact have a different address for her. And I believe there was recently last year an FOC hearing. So we utilized that address. And because it was confidential, I mean, I haven't disclosed it obviously to my client. We also discovered, we found Ms. McConnell on Facebook. And I did also send her the motion in today's notice of hearing on Facebook. We recognized her account by her picture, Mr. McConnell and I did. So, so those are the two methods we. Sorry.
I'm satisfied then that she has actual notice of this proceeding, and she's not filed anything in opposition to your request. She's not appeared today. I'm double checking. She's definitely not in the waiting room. I am going to grant your motion. I'm going to sign the proposed order releasing judgment lien that you submitted.
Okay, great. And then
Thank
does your
you.
office mail that order to us, or do we need to obtain it a different way?
I'll make sure someone gets it to you.
Okay, very good. I appreciate that. Thank you, Your Honor.
You're welcome. Have a good day.
Thanks, you
Good
too.
day, Mr.
Thank you. Bye. Thank you, Your Honor.
Bye. Don't want to do that. So Ms. Berger, I just wanted to let you know, it looks like Ms. Denke was here earlier. It looks like she might have stepped away for another hearing. I just wanted to let you know what was going on. I'm going to put you back in the waiting room and call another case.
Perfect, thank you.
You're welcome.
Morning, Judge.
Good morning. Getting everybody in here. Okay, this is Beisel versus Beisel. Tiffany Burks on behalf of the plaintiff, Charles Kronzek, for the defendant, and the plaintiff, Bridget Beisel, is present. Tiffany Burks. You gonna be okay? All right, and Mr. Kronzek, were you expecting your client?
I was not, Your Honor. She doesn't have a good internet signal.
Okay, well, I can identify with that. I have a really good signal here, but when I try to do stuff from home, it's kind of challenging.
Yeah.
Okay, so we are here on the plaintiff's motion to modify. I can't remember, custody and parenting time?
Correct, Your Honor.
All right, I've read that. I've read the response. I am a little concerned because of the fact the case is pending in front of the Supreme Court. I can envision a quagmire if I were to do something to alter that judgment while it's on appeal. Would you please address that?
Yes, Your Honor, as it relates to that issue, and quite honestly, that's sort of the delay in filing this motion to begin with, because we're in this limbo stage, as the court knows, of is the Supreme Court gonna grant leave or deny? So, but at this point, 7 months have passed since application was made, and we still don't have a decision by the Supreme Court. In that time period, parenting time is denied. We were here, Your Honor, on the last motion about pickup exchanges. And at this point, so much has changed that it's really in the child's best interest to have this reevaluated and not wait for that Supreme Court decision. I do recognize it puts the court in a tough spot though, because if they affirm the Court of Appeals decision, then we're back to the temporary order. If the Supreme Court hears the case, then who knows what will happen. But I think to not evaluate it in the interim, it does a disservice to the child, really, Your Honor.
And I am sympathetic to that. Mr. Kranzik, are you doing the appeal yourself, or is there appellate counsel involved?
There is appellate counsel, Your Honor. One thing that I noted in my response to counsel's motion was the amount of time. And if counsel says it's 7 months, I believe her. That's not what we typically see in these custody cases. And as Your Honor knows, the Court of Appeals ruling was a pretty radical departure from what we have all come to know to be Michigan law over the years. So the fact that so much time, this 7 months, has now passed, would cause you to speculate that, gosh, they must be taking a real hard look at this thing. And maybe the delay is intentional. I don't know. I don't have any insider knowledge. I will tell you that in a general sense, I don't know how many bites of the apple we want to take in this case. Counsel has asserted that it's in the child's best interest. I would tell you two things. Number one, I don't believe there's any Vodvarka threshold that's been crossed. We can talk about that in a moment, but my view of the world was to keep things less complicated. We ought to hold this motion and try to put a Band-Aid on this rather than to do surgery. And we've made some proposals, and I'm not going to, get specific because I'm not allowed to get specific, but I've made recently, weeks ago, a Band-Aid proposal, and I can't even get a response from this plaintiff to our Band-Aid proposal. So I don't know. I think we've just got more of the same over and over. Back before they were even divorced, the plaintiff was a canine police officer. And in the course of her duties and every other police officer's duties, they work shifts. They're subject to getting called in for emergencies.
Mr. Kranzik, let me stop you. I wanted to ask you whether you were appellate counsel, mainly to know what your sense is. It does seem to me like a significantly longer time than what the Supreme Court normally would take on an application for leave to appeal. But I was hoping that appellate counsel could say yay or nay whether that's the case. I mean, it seems like a long time. Are they on the verge of making a decision? I'm very sympathetic to the plaintiff's situation here, and waiting in this, what's going to happen before I do anything, I'm sure is not very palatable to her, and I understand that. On the other hand, I am. If the Supreme Court were to grant leave tomorrow, or, I mean, sometimes don't they, in lieu of granting leave, remand for further consideration? I mean, I just see the potential quagmire that would be created if I were to amend a judgment or amend a custody arrangement while all of this is pending. It could just get so messy. And frankly, once this, if ultimately my judgment is affirmed, I absolutely will be referring this case to another county. It just doesn't make sense for me to stay involved. And as I'd indicated previously, when I unwittingly granted a change of venue prematurely, it certainly makes sense that whoever's going to be deciding whether there should be a change of custody should be a judge in a jurisdiction where the parties are present. Anyway, so I don't want to deny either of you the opportunity to present argument, but I think Ms. Burks justly should have the first word on that rather than hearing your opposition to it, Mr. Kronzek, since it's her motion.
Very well.
Thank you, Your Honor. Is that permission to go into the motion?
Well, I would, I don't know if your firm is handling the appeal, whether you have a handle on what's going on with the Supremes.
My firm is not handling the appeal, Your Honor. Lisa Speaker represents plaintiff on that. My understanding of Supreme Court is that the average time frame is 4 to 7 months. I'm guessing, and this is just a complete guess, that there are potential delays due to COVID. At this point, we're unsure. We're kind of in that limbo zone. It's a tough decision, you know, and I think at the very least, and part of the reason for bringing this motion is that, you know, if so much more time passes, then our burden is even higher, because then the established custodial environment gets even longer. And we are now in this position of, well, you know, the child is so far removed from plaintiff that, you know, the court's going to be in a tough spot, whether it's this court or another court. And I think at the very least, parenting time needs to be addressed since it's being denied at this point. I can go through the, you know, specific arguments that I have about custody, and that's standard.
Well, I have no hesitation about addressing parenting time denials. The pending appeal does not, in my mind, pose any obstruction to me weighing into enforcing the order that's currently in place. So I can certainly address that.
Okay.
So what's happening with parenting time? What's being denied?
So on that basic level about the denial of parenting time, I think part of the issue here is that the reliance is on the reasonable rights parenting time of friend of the court. And there's no specific midweek day specified there. It's just a midweek, you know, parenting time. So plaintiff's schedule changed. She had, you know, she's a police officer, as this court is aware. With Muskegon Police Department, her schedule changes 1 time per year. This doesn't mean she changes completely, you know, from this day to another, but her schedule may change from days to nights, which is what has happened here. So she's unable to exercise every Wednesday because she's working on alternating Wednesdays. Her proposal is to make that a Tuesday or make that a Monday. You know, the pushback that we've received, or that she has received on that, and talking with defendant, is that that's too much of a change for the child, that the child doesn't understand what a Tuesday this week and then a Wednesday and then a Tuesday and then a Wednesday, that's not good for the child. I mean, my argument is that it's not good for the child to miss time with plaintiff. So we could go back and forth on that, but really I think we just need a set parenting time schedule by the court rather than this reasonable rights parenting time that, you know, can be interpreted differently.
A child as young as this doesn't know the difference between Tuesday and Wednesday. I don't understand that, if that is indeed the objection. Give me just a second. I wanted to look at specifically what it said. Midweek parenting time, after work or after school, each and every week. With the previous schedule, that was a set day. And now with plaintiff's current schedule, it can't be a set day. It needs to vary depending on the week. Give me an idea of how often that does vary.
Well, that would be a consistent schedule, Your Honor. So instead of it being every Wednesday, then it would be, so if we look at it in a 2-week block, 1 week it's going to be Tuesday, the next week it will be Wednesday, then it will go back to Tuesday, then Wednesday. It will just alternate between Tuesdays and Wednesdays.
And does it make any difference to anybody if instead of alternating Tuesdays and Wednesdays, it's alternating Wednesdays and Thursdays? I mean, is that?
No,
is
no,
that-
Your Honor. And my client just reminded me that Mondays, and I'm saying Tuesday just as an example, but she actually reminded me that Mondays are better because then the parties don't have to interact. She can actually pick her up from school. So I did include her schedule in the motion where it shows what her work schedule is. So if that helps the court with a visual, and I could
let me-
tell you what page
let me
it's
find
on. It's on page 5, Your Honor.
Well, that's wonderful. Can you screen share that with me?
Oh, let me close all my other things so you don't see my mess on my computer screen, but yes, I can. Okay, share screen. This one. Can you see that, Your Honor?
Oh, I can, thank you. So what days does the child attend school?
My understanding, Your Honor, is that it's Monday, Wednesday, Friday.
So if we're limiting interaction between the parents, it would seem that Monday and Wednesday would be best, or Monday and alternating Monday and Thursday. And I would think there's alternating weekends, correct?
Correct.
So I don't know how the alternating weekends match up with plaintiff's schedule.
So
But
right now the weekends they match up with her schedule. So when she's off, that's her weekend.
So I realized you had proposed Tuesday and Wednesday, but it just suggested that Monday actually works better for your client because she's off and she wouldn't have to interact with, she could just pick her up from school. And that's also true on Wednesdays, correct?
Correct, Your Honor.
Okay. Let me hear Mr. Kronzek's response to that specific issue.
Okay.
Thank
Do you
you,
want me to
Judge.
stop the screen share, Your Honor, or keep it up? Or did you
Why don't
already?
keep it up?
Okay.
No, yeah, let's just keep it up. I can still see you guys in the frame to the right.
Okay.
Go ahead, Mr. Kronzek.
Thank you, Judge. Judge, I understand what counsel is saying. She said much the same thing to me. Again, without getting, well, I guess at this point, I am going to get super specific. And if you think I'm out of bounds, please tell me and I'll stop. But my Band-Aid approach was advocating for less time in the car for this youngster. So I don't believe that this whole issue is just about the plaintiff, because we do have a defendant and we do have a minor child. And the plaintiff herself elected to live a long ways away from the defendant and from her place of employment. And that means putting a young child in a car and transporting her back and forth. So my Band-Aid approach, pending whatever the Supremes decide to do, was put the tack the plaintiff's hours. She misses in quotation marks, misses every other Wednesday when she's working, and there would be several hours every other Wednesday. I suggested tacking that on to her weekends, thus eliminating putting this youngster in a car for a few hours needlessly, or a couple of hours anyway. So my suggestion was pick up the youngster early, drop off the youngster late, but let's just tack it on and not have travel time in there. That's what would match up for my client's schedule and for the youngster's schedule. But to that, I didn't get a yes, I didn't get a no, I didn't get a maybe, I didn't get anything, despite making multiple inquiries.
All right, well, that sounds like a reasonable proposal and a reasonable approach. What Ms. Burks is suggesting sounds like a reasonable approach. I don't think I can force this. I can encourage you to talk. I can set a time for me to actually hear testimony from both of the parties and make a decision about modifying parenting time, and hopefully encourage the two of you to talk. I mean, I will tell you the concept of the child spending less time traveling. I think it's a good one because less time means more time with mom. In a setting other than in a vehicle, but I need to hear from both parties the impact they believe it would have on the child, the relative convenience or inconvenience to each. And I can't do that at a motion hearing. I can only tell you both, I am going to do something to make sure that the plaintiff gets this time. I only limited her to the time that I did when I did the judgment because of the vast distance between the two. That's changed. And I think it absolutely needs to be addressed, but I can't do it. I am not inclined to modify custody at this point. I am very much inclined to modify parenting time. I think it's definitely in the best interest of this child to have a strong relationship with both parents. If she's not being able to enjoy all of the time I afforded with the plaintiff, we need to figure out a way so she can. So here's what I'm going to do. I'm going to ask my secretary, Dawn, to find a date. I'll have her get with both of you to make sure it matches with everyone's schedule. In the meantime, I would strongly encourage the attorneys to talk to try to work something out in light of what I've already told you. I am denying the motion to change custody without prejudice. And in fact, you may simply renotice this motion at a future date when we have some kind of a decision. And I'll deal with it then. I'm just very concerned about the quagmire that'll be created if I try to weigh into that now. Plus, again, that changing custody is going to involve some extensive evidentiary hearings, and this isn't a convenient forum for either party. It's granted we can do some stuff on Zoom, but we're moving to phase 3 next Monday, which means if parties insist on a in-person hearing, I'm going to grant it. So let's do this. I will find a date. Have my secretary find a date. In the meantime, I encourage you to talk.
Question, Judge?
Yes.
Do you believe it would help the court at all if we need to go to another date to spend 5 minutes, if we can make it work with the appellate attorneys just to weigh in?
What do you mean? In front of
Well,
me?
you inquired about, do we have any insight what's going on at the Supreme Court? And neither counsel that's here today is appellate counsel. Would it assist you at all to have some input from the, not substantive input, but procedural input from the appellate attorneys?
No, I don't believe so. I've already made my decision, and I'm not going to weigh into this until we have a decision.
Good enough.
I'm not going to do a full-blown custody hearing, evidentiary hearing, while we're in this legal limbo.
Fair
But
enough.
I absolutely am going to fix the parenting time issue. If you guys can't resolve it, I will resolve it.
Good enough.
Thank you, Your Honor.
Okay. Thank you.
Judge. Good morning.
Have a good day, everyone.
Likewise.
You too, Judge. Shoot. I'm trying to figure out how to stop.
Apologize for the delay, Judge. I was here first, but then Jordan ran out of cases, so she called me over there.
Hello.
And I saw you. Hold on just a second. I brought somebody in that's not for this hearing. Mr. Hugaboom, I'm going to put you back in the waiting room. Okay, this is Gates versus Gates. Ms. Denke represents, well, I'm not sure. Who do you represent, Ms. Denke?
Judge, I represent Ms. Negus on the contempt issue.
Oh, okay. Was that by appointment?
No, Judge. I retained, I substituted in for, I believe it was Phil Curtis who was appointed.
Okay, thank you. That was my confusion. I was a little concerned I was going to be seeing two attorneys here this morning representing Ms. Negus. Okay, and Ms. Berger represents Mr. Gates.
Yes, yes, in the motion for change of custody.
Okay, and both parties are present. So I want to address the show cause first. I will tell you before I hear from the attorneys, I am extremely frustrated with Ms. Negus's behavior. It has been, she can't even contain herself when she's in front of me and I'm asking her to be quiet while I'm trying to make a ruling. I mute her device and she unmutes it and continues to run her mouth when I've told her to be quiet. And I just reached a point of absolute frustration. The last thing I like to do is put people in jail. But when I have people that simply totally flaunt my authority in this courtroom and flaunt my orders, I have nothing left to do. First, I threatened her with jail and then held it in suspense. It didn't make any difference. And then what it appears like, from jail, she's continuing to harass Mr. Gates. So what I need, first of all, is to hear some testimony from Mr. Gates as to what exactly happened while Ms. Negus was in jail.
Judge,
So Ms. Berger?
Judge,
Yes, Ms.
if I might, because this is criminal contempt, you're seeking to punish my client for behavior that's already occurred. And because of the serious nature of this situation, my client was only released from jail this past weekend. So she and I have not had a reasonable opportunity to prepare a defense, which is her right in this kind of a serious situation. She absolutely wishes to contest these allegations. I can tell the court that it is my understanding that there have not been further problems. She and I have had a couple opportunities to speak regarding behavior going forward. She has engaged in counseling for her PTSD, which it would be certainly my hope we'll be able to provide her with some help and with some assistance there. But we're asking that the court schedule this for an evidentiary hearing so we can make a full and complete presentation to the court of what was going on. My client had been informed by Mr. Gates that he was not going to try and take their son away. And then a few days later, she gets served in the jail with a motion to change custody, and understandably became frantic regarding that. But she has not, other than, and I believe just an exchange of text messages regarding their son that were appropriate recently, has not been engaging in any further contact with him, and understands that she cannot do so. So with respect to dealing with the contempt issue, I would ask that the court schedule that for a separate hearing. I know in speaking with her, while I have not filed an appearance with respect to the custody situation, she recognizes that is something that is going to need to be set for an evidentiary hearing. So it may be that the court wants to address both those hearings at the same time.
Ms. Berger?
Well, Your Honor, I understand Ms. Stanky's position on this. However, Ms. Negus has known about this since February 1st, and the court did appoint her counsel in which to be represented. And I'm not even really for sure why she didn't get out, because she was scheduled out by her own statements as of February 14th. So that's what she was telling her son while on the telephone, one of the many phone calls that she kept telling her son that she was in jail, that why it takes so much. We've already adjourned this once. The court obviously is well aware there's telephone call after telephone call going forward where Diane can't control herself. And the hopes is she would just learn to keep quiet, but I don't find that all of that authentic at this point in time. I mean, she's even using third person communication to try to get this. I don't think that it makes any difference if we delay this out a year. The situation is the situation where my client can testify as to what was being said. I mean, that's the violation. The evidentiary hearing, as far as a change of circumstances for the motion for change of custody, obviously the court, that would require a factual basis, and we're ready to proceed to have that set. But as far as the violation of the mutual restraining order, this court is well aware of what's going on. Again, a year from now, 6 weeks from now, taking testimony of what's already occurred from issues at the jail isn't going to change anything. And
So.
But it would allow me to go back and watch the prior hearings. She did expect to be out on the 14th because when she was booked in, they told her that she would get good time and be released on the 14th. Then the jail realized after the fact that you don't get good time on a contempt case. You do the entire 30 days. You don't get any release for good time. So that's why she was not released on the 14th as she had expected.
Well, Ms. Dakey, I am very sympathetic to your need to adequately prepare. I have no problem granting an adjournment. What I want to find out is confirmation from what you're telling me that it stopped. Is Mr. Gates still getting phone calls? And I never got the impression from Mr. Gates that he wanted to punish Ms. Negus. The impression I always got from him is he just wanted her to stop. And if she stopped, I'm more sympathetic to giving a little more time for adequate preparation. That was my goal from the outset, is just to get her to stop. I mean, has it stopped at least for a couple of weeks?
I don't know when she got out. So. But I would have to ask Mr. Gates. I don't know.
I'm asking him. Mr. Gates, has it stopped?
Since she was released on Saturday, the only communications I've had with her have been civil relating to Jameson, but again, it's only been 5 days. She's done this before where she's gone a week or two with fine, and then it's back to the same old.
John, I'm not letting her off the hook, sir. That's not my point. My point is how much time before we come back to deal with it. And if she's still doing it, that time would be much sooner rather than later. So here's what I'm going to do. I'm going to try to find a date with Dawn. I don't have a problem dealing with both at the same evidentiary hearing. However, if there's a single violation of my restraining order between now and whatever date is set for this hearing, I will require an immediate hearing so that I can put a stop to it.
Yes, Your Honor. And I'll encourage my client to only communicate in writing via text so that there's a clear record and she understands the court's orders.
All right, I will have Dawn get with counsel to find a date that works on both of your schedules, and we'll proceed as to both issues at the same time.
Thank you, Your Honor.
Your Honor, can I ask a question, please?
Certainly.
One of the things that I had asked for in the motion for the change of custody was to allow me to place Jameson, our son, into counseling. I would like to ask that I be allowed to do that sooner rather than later. I think it would be very beneficial to his emotional well-being to get that started. I tried to offer that to Diane a couple months ago, and she was agreeing until she found out that she wasn't going to be able to be privy to what was said between Jameson and the counselor, and then she said absolutely not. So I would just like to ask that I be able to get that started with him.
Well, I'm not sure what exactly is meant by being privy to. I do certainly think that both parents need to be in communication with a counselor as requested by the counselor. I wouldn't expect any counselor worth his or her salt to turn around and tell the parent everything that the child is telling them.
Right.
I leave that up to the therapist to decide what to reveal to the parents and what not. Ms. Berger, does your client oppose counseling?
No, sorry, my
my-
client was, and I would agree with what he said. If, I think
Sorry,
the
I'm
communication, you're fine. The communication was, I think Diane wanted to be in each one, or at least the therapist telling her what the child was saying, which is what is to be avoided. Obviously the counselor should talk to both parents as to maybe some recommendations. That's what my client was getting at. So
And I'm sorry, I
that's okay.
called on the wrong counsel. Ms. Jenkins
That's
is
fine.
your client.
Judge,
Counseling.
I think that both parents should be involved, or the attorneys can try and correlate that with selecting a counselor. It shouldn't be something that Mr. Gates just does on his own. And both parties should be meeting with the counselor. But I agree with the court's statement that the counselor is going to maintain a level of confidentiality in terms of what the child is saying in their private sessions. But clearly there
Right.
needs to be some work with the family.
I'm going to order that the child can be enrolled in counseling, but the parties through their attorneys need to confer as to who the counselor is going to be. If they can't agree, I will pick one. I hope you both can agree. And the involvement of the parents will be dictated by the counselor.
Thank you, Your Honor.
And I expect both parents to cooperate with that. Okay, thank you.
Thank you.
May I ask a question?
Sure.
Do we have to communicate through the attorneys for the counseling, or can we communicate directly with each other with regard, with all due respect, my attorney's not free or, low cost like his is. So I would rather.
As long as it can be done civilly within the
Yes, sir.
bounds of my order, yes.
Right.
The instant it changes otherwise, then it needs to go through counsel.
Correct.
I'm not going
Thank
to
you.
subject Mr. Gates to any more of the kind of behavior that I've seen.
Understood.
Thank you, Your Honor.
Thank you.
Okay, thank you all. Good luck.
Thank you.
Ms. Negus, you can go ahead and disconnect.
Well, Peter's going to be disappointed there weren't fireworks on that case. Okay. Let's see. Lopez. Okay, good morning, gentlemen. Lopez versus Lopez. We are on the record just because I've got several things going on, just so you know. Do either of you have a client present?
I think mine should be as well, Judge. We just gave her the password or the the login number again, but
Is there would either of you like an opportunity to have private conversation with the court off the record?
I don't object to that, Judge. Fine with me.
That's fine.